Hello, and thank you for joining us today. I would like to welcome you to Novus Law Firm and Fortney Scott's Back to School webinar on higher education post-COVID-19 legal and compliance concerns. This briefing will be recorded. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's webinar is a discussion on disability and privacy law issues to consider when returning faculty and staff to campus. Presenters include attorney Natasha Baker from the Novus Law Firm and Fortney Scott attorneys Elizabeth Bradley and David Fortney. I will now turn the program over to David Fortney to start our webinar.
Terrific. Thank you very much, and good day, everyone. We're really delighted to have everyone back. This is the second in a series focusing on higher ed, and we're really pleased to have Natasha Baker joining us today. Thank you, Natasha. Both Natasha and Liz are both real subject matter experts on higher ed. Their practices focus on that, and we have a lot of really great information to share with you today. Let me take care of a couple of preliminary matters that I'm going to serve as the moderator and allow our subject matter experts to really delve into this. First of all, obviously, what we are providing today is detailed information and updates on a number of matters that involve legal developments. However, we are not providing legal advice. You should consult with your appropriate counsel, in-house counsel or outside counsel. Many of you are clients of one or both of the firms on this call, and we appreciate that. But it is important to understand how these developments actually affect your specific situation that you confer with qualified counsel. Thank you. Next slide. There we go. So let's talk a little bit about our agenda and what we want to cover. We have only 60 minutes, and we're going to fill every moment of it. I do want to reiterate, if you have questions, please use that chat box, and we will pick those up as we go along. And happy to do so. And in the past, we found that the questions are excellent, so please keep them coming. But we're going to focus on, as indicated, accommodations, how to handle requests for accommodations. We're going to do so not only in the ADA, which I think most people are generally familiar with, but we're going to crosswalk that into the COVID-19 circumstances that we all are navigating. Some of the most vexing issues involve testing. What types of tests, how to conduct the tests, obviously the privacy considerations, and also contact tracing. What to do, how to do it, how not to do it, hopefully, and some of those points, and once again, privacy considerations. These issues really reflect what we are hearing from clients regularly. And so we know that most of you are rapidly looking within the next 6 weeks to robustly stand up and resume operations in every sense. And as a result, these questions have really jumped to the fore. So let's jump right into it.
So in this first segment of the presentation, we're going to be talking about the interplay between the ADA and COVID-19 related requests. Every employer, you're getting these requests. I don't want to come back to campus. Questions about what can be done for COVID-19 related reasons for requests either to work from home, modified workplaces. So in this section, we're going to start by walking through some definitions for you and to put into context the ADA and the CDC and some other definitions. And then we're going to kind of walk through some policy recommendations and then ultimate implementation recommendations. So bear with me, we will walk through some definitions.
Good.
And on
Good
the first, the first thing to remember is what is an individual under the ADA, an individual with disability. That is a person who has a physical or mental impairment that substantially limits one or more life activity. That's sort of the general concept. It's also a person who has a history of such a record or who is perceived to have having such an impairment. So remember, under ADA, it's a physical or mental impairment substantially limiting one or major life activity. and under this, just to be clear, if somebody has COVID-related symptoms, that is not necessarily a disability. And that's one of the things that we're going to talk about, and that's a theme that we're going to thread through this provision. So COVID-related symptoms may rise to the level of a disability. Does the respiratory issues or other symptoms, is it a physical impairment that substantially limits? But COVID itself, diagnosis itself, is not an ADA disability. Moving on the next slide.
But indeed, as you're doing that to the next slide, that's something that the EEOC has recently issued some guidance on and clarifying that vulnerability that you just described, Liz, does not per se constitute a disability, and to be careful of that in terms of how you affirmatively deal with it. Okay, so let's talk about the CDC.
Yeah, so thanks for having me. Good to see everyone and have everyone back. And we're advising the same thing. You got to really maintain this distinction with respect to the existence of a disability, and that EEOC technical guidance from June 17th is really helpful if you hadn't had a chance to parse that. And where we think that there's a potential source of confusion here is how the CDC has identified vulnerable populations, including anyone who has difficulty accessing medical care, communicating, maintaining independence, requiring constant supervision, may need help accessing transportation. They've identified sort of this vulnerable populations category. And then on the next slide, this other category that the CDC has also identified with respect to people who are at higher risk. And so this is where you have to really be careful and really start parsing that the CDC is operating under an entirely different statutory scheme than the ADA and the EEOC. So they've identified these people who are at risk over 65, often a lot of faculties, those who have what we're seeing a lot of the immunocompromised, chronic lung disease, or some of the other exacerbating conditions here. And the reason we're really parsing this distinction is that being identified as vulnerable or at higher risk is not the same thing as having a disability under the ADA or your state law. So you have to really parse out what legal scheme you're operating under. And so we just wanted to flag that. There are still things you can do for people here. We're not saying you just ignore the CDC, but the CDC's identification of these groups isn't the end of the story. So just make sure you really understand that and how this works. And then there, of course, as fun for employment lawyers, there have been some other new employment updates that Liz is going to cover on the next slide, sort of how this interplays with other recently issued definitions.
Right. And so in addition to the ADA and the CDC definitions, another set of areas in which you qualify for sick leave is going to be important for our considerations when you're drafting your COVID-related workplace modification policy that we're going to get to here in a moment. So under the emergency paid sick, you're deemed to have a COVID, you qualify for COVID-related sick leave. Obviously, if you're subject to a quarantine or isolation, if a healthcare provider has advised you to self-quarantine, if you're experiencing symptoms, those are pretty obvious. The next slide has additional work elements under the emergency paid sick leave. And these start to come into play too, because they're not necessarily just sick. And again, just because somebody qualifies for emergency paid sick doesn't mean they are sick, and it certainly doesn't mean that they qualify as an individual with a disability. So these are some tiers of levels of definitions of individuals who qualify for different consideration when they're coming back to the workplace. And so I think the one that we're going to be seeing a significant amount of is individuals who need some sort of modification in order to care for their kids. Because I know, schools around here have already come back and given families the option that their children, high school age and younger, cannot go back to school next year. It's all remote, or they can do 2 days in and the rest out. So this is definitely an area that we're going to be seeing requests of how do we have a modified work schedule for COVID-related reasons, and most certainly does not advance up into the ADA range of reasonable accommodation pieces. So these are some definitions that we're starting with before we start talking about your policy considerations. And with that, then Tasha, I'm going to turn it over to you to say, now that we've decided who's ADA and some of these other definitions, let's talk about that ADA reasonable accommodation process.
Sure. So this process you're all familiar with. It involves seeking a reasonable accommodation that doesn't pose an undue hardship. They have to usually provide qualified opinion from their treating healthcare provider. It's a very formal process, and it's so intended to confirm the existence of the disability, the needed accommodations, the interactive process, which is a separate requirement, and make sure you go through that process and say, what can we do to accommodate this person? So because that's such a formal process and so is mandated under the ADA and state disability laws, it's really important that you only apply that process to those who meet the definition of a qualified individual with a disability. Do not apply that process to the CDC vulnerable populations, to those who are at risk, to those who may qualify for the FFCRA paid sick leave. That's as we said, the CDC thing, that was a helpful definition for some purposes, but for employment purposes, it doesn't trigger a lot of process or protections. The paid sick leave, you may be entitled to paid sick, but you are not anywhere near entitled to a reasonable accommodation. And so I think this is really key. Everyone that we know in higher ed is really working to protect their employees, to be reasonable, to be as flexible as possible in this very fluid situation. But the problem is it is really fluid. And once you go down a legal pathway of a disability accommodation, where you've changed accessibility requirements, you've restructured a job, you've modified equipment on the basis of an ADA accommodation, that's a fairly formal and difficult path to unwind later. So that's why you really need to make sure that this is you're under the right process. You can put limitations on the duration of reasonable accommodations. The EEOC technical guidance from earlier in June talks about all the different sort of ways that you can approach the reasonable accommodation process. But what we're noticing is this lack of a distinction between the reasonable accommodation process and the temporary modification that you may be doing to make people feel safer, feel more comfortable coming to work, that really has nothing to do with the ADA process. So just be mindful of how you use those words, how you talk about it. I know Liz is gonna hit the next slide and really key in on some of those distinctions between that more formal ADA process and this.
So we're going to spend some time on this slide, and this is now that we've kind of laid the foundation of some various, we're digging in. We laid the foundation, but this is, so the very first thing that you should do is, one, as Natasha said, do not use your reasonable accommodation policy and practices as they are set for these temporary modifications. And if you notice, we're using the word temporary modifications. And we think it's really important to use a different term. You don't want your employees confused about which process they're going under. You want to make sure that there's a line that this is the ADA accommodation process versus COVID-19 temporary modifications, because this is often an ADA accommodation is often for the duration of an employment. It's generally, and depending on duration of the disability, but it's often a more permanent, consistent accommodation that is provided, often, not always. But we hope these COVID-19 will all be temporary. We hope that we do come out of, I'm optimistic, folks.
I love the optimism, I love it.
But if these modifications, ultimately, maybe it's just a wholesale change to the workforce in the way, and then it's not even a COVID-19, it's the new normal. But we want this to be a modification of policy. So, as we're trying to, be more consistent in using that language, and we recommend you all do too. So again, do not just amend or adopt your ADA policy to now cover COVID-19. But that doesn't mean that policy is useless. You don't have to completely reinvent the wheel. It's a great starting place for you to look at. You can peel back some of the formality that needs to be done, and you need to update it. But, looking at this, you're going to be agreeable to, and the modifications, and we're going to talk about the different types of modifications, but they fall into two main categories. Modifications to your work schedule or work from home is part of that, remote working, versus modifications to the workforce. Because while we know we're going to have a lot of people who want to continue working from home, somebody has to go back in. I mean, there's a percentage of the workforce. I mean, there's going to have to be, so we're going to talk about it on both sides. But let's start with when you're drafting your policy. First of all, you have to have a policy. If you are making these modifications right now, piecemeal one-offs, pause. Just pause for a day and get a policy together. Because one of the most important things that you need to be doing to ensure that you're not is administer it centrally and be consistent. Because you do not want to walk into any sort of a discrimination claim because you allowed somebody a modification that you disallowed somebody else. And so think of a central administration, be consistent, clearly define the permissible reasons. And you have options here of what to use. So one of the reasons why we went through the federal paid sick leave, the 6 bullets, is you can be consistent. You could have so that your modification policies align with your federal paid sick, and those are reasons that are accepted already, and that's an easy fix. You can add those in. We recommend that you do. That gives you some guide rails. You can also add additional defined reasons, some things that are unique to your workforce, things that you are seeing come up. So think about what are the reasons you're going to allow this leave, but don't be overly broad, because then there's no guardrails left. So think about that. Another thing we need to think about is, are there going to be termination provisions? Because you don't want to get in a situation where you've allowed a modification and there's no rules around when do you stop that modification. And there's going to be circumstances that may arise that you're going to have to say, okay, it's time that we can no longer have you splitting your job or whatever the modification is. So that's going to be, that I think is going to be the difficult provision for these contracts to write, because they're often unique reasons why you would. So thinking about that, some of the reasons would be business, obviously the vague business necessity, individual no longer needs, the modification is obvious. Potentially the individual demonstrates a no longer need. And we're going to get into that, is if you make these modifications, do you see that they still need it, and are they just staying out on leave longer than they need to be? Because I do anticipate we're going to get to a point, everyone wants to be friendly and cooperative, and we want to bring people back. We want to give them, there's going to be a necessity where, no good deed goes unpunished, right? And it's going to stray too long. So that's going to be important. And another provision, and I think we're going to talk about this a little bit, is kind of how this could come up, but I think your policies need to have a provision for breach. If you're agreeing to a modification based on a representation that somebody has an illness, or they have a child need, or they are, because of their fear of being exposed, if you find that is not a valid reason, if there's some sort of reason why that you confirm that they provided false information, or they're no longer abiding by their own personal limitations, there needs to be provisions for breach, because simply revoking the leave may not be an option in your workforce. So then there needs to be some hook to ensure that they're complying with the agreements. So that's a general.
I would chime in, Liz, just on that central administration. I know a lot of our schools are really decentralized, but the risk of disparate treatment here is really real. And so the EEOC flagged its caregiver guidance again, just reminding that you can't administer leaves of absence or accommodations or modifications or working from home on the basis of sex or gender. So things that may appear to be helpful on their face by a particular department chair or division, if it's not being administered centrally, you may not catch that it's actually being administered on a differential basis. So just things that sometimes in higher ed seem like we're trying to help people end up being not helpful.
Can I ask a question?
Actually, let me chime in. Oh, go ahead.
Oh, go ahead. No, Liz, I was going to ask you. So you've laid out kind of, and Natasha set up the interplay between the ADA, the COVID, vulnerable populations. Many higher ed institutions are also federal contractors, and there is the 503, which is kind of ADA-like. But are there any additional or unique considerations or concerns for universities that also have a 503 disability-related obligation?
Absolutely. So OFCCP, well, pause point, and OFCC previously announced that higher ed is going to be a targeted industry the next time they send out their corporate scheduling announcement letter. That universities are going to be on the list, sorry. And one of the type of audits that OFCCP is starting to do are called these 503 audits. It's the Individuals with Disability Compliance audits. Part of those audits is you have to provide a log, information about all of your reasonable accommodations, your ADA reasonable accommodations. So this is another reason why you do not want to conflate your ADA accommodations and your COVID-19 modifications, because if you're doing those under the same policies, if you're doing that, it could conflate it, and it could ultimately, you'd have to turn over your COVID-19 modifications could be in your data to the OFCCP, which they do not need to be because they're not ADA. So that's the other reason why to keep them separate. If they are separate policies, the COVID-19 modifications do not come in. If you are maintaining the records with your ADA, you could likely pull them out, but I'm guessing it would ultimately be submitted. So you want to keep those separate. So yes, that is something that any federal contractors need to be very cognizant of right now. Thank you, David.
Yep. And I think in your next discussion, you'll be able to address this, but I do have a question about how do you verify a breach? You've talked about the guardrails and the systems when most places are relying on self-reporting and the honor system, one of the cornerstones. How does that fit with the type of protocols that you're really describing here, which are more prescriptive perhaps than we've talked about before?
Liz, you want me to take that?
Go for it.
One of the key concerns and things that we have started to see is people who say, I need a temporary modification to work from home because I myself have anxiety, I am concerned, or I live with someone who's immunocompromised, so nothing that's going down disability-related accommodation, but this temporary accommodation or temporary modification process, and then it's showing up in the workplace via other coworkers that someone who's been granted that temporary modification is, perhaps shown at a lively restaurant around town on social media, or other activities are coming up that start to make you question whether that person is truly concerned about exposure risks or the risks associated with bringing something home to someone that they live with. So it's almost like what we see in workers' comp, right? Like sometimes you see a lot of those, the workers' comp is essentially people are put out on leave, and then you find out later on that someone has a different job or a side job, or they're the workers' comp investigator does some diligence on their ability to function. So I think but it's people are pretty amped up about this, and kind of you see it on the next door blogs as to who's wearing masks and who's doing what, and we're seeing it in the workplace as to who's where and are they really out in public and what are they doing. So I think that we'll see more of that continue. That's what we're seeing out here. I don't know, DC.
Yeah. Well, and I think to that, and I know we're kind of skipping to the bottom of the slide, we'll get back to the top of it here in a moment, but to that end, and it goes back to what's in your policy. So if you have an employee who says they're immunocompromised, or maybe not, they're just nervous, their anxiety, they don't want to be around people. You can go back to the next slide. Thanks, Valerie. But the question is, what is the penalty for them? How do you remedy that so that right? And you may not want to bring them back into the workplace. You don't want to necessarily revoke. Maybe you can, depending on the modifications your workplace and the safety procedures you're going through. But maybe if you have a policy that allows for unpaid leave, that they have to go out on some sort of a penalty provision to sort of try to keep some guardrails on that behavior. Hopefully you never have to implement those procedures, but if you have something in your policy, it does give you some sort of hook for if you have a problem employee.
And in California, you have to be careful about, taking action on the basis of an employee's external, personal, social activities. So I think you want to have a policy that says you could address this, but it's probably going to be an investigation and assessment. And, frankly, like we saw here, a lot of people attending local barbecues related to college graduations. And so, okay, are you going to fire someone because they have asked to work from home and they went to a local, they went to their beloved family member's barbecue graduation? No, probably not. But so it's super, super delicate. But it does raise the concern of, okay, if they just attended that, and then here we actually saw a spike after all those barbecues completed, and they're tracing a lot of those back to those large gatherings here. So it does raise a concern about then they can't come back for at least a few weeks as they need to quarantine. Right. So it's going to be super delicate. Right. Like this whole COVID thing puts employees in the weeds of the employee.
Let me ask another question from our audience.
Sure.
From our audience. Okay. If you grant an accommodation to a faculty member, for example, do they have to then follow it? So you've given the accommodation, do they have to follow? For example, if someone who is higher risk for sickness has gotten an accommodation to be remote, does the institution have to tell them they can never come to campus?
Oh, so this is interesting. Yeah. So if it's a temporary modification, so they are granted a request to work from home, what you cannot do is you cannot hold someone's status in a CDC vulnerable population, their age, you can't hold that against them. So if they wanted to come to campus and they, passed all the other tests that you're requiring of employees, they certainly could be allowed to do it. So it's it's a one-way street as to what you're granting versus if someone says, I tried teaching online for 2 weeks, I'm not going to do it. I'm going to come into my office. As long as they meet all of the other sort of return to work categories, then they would be permitted to do that. That's how I look at it.
Agree, absolutely. If you're relying on the age. Yeah, well, no, I totally agree with you. If you can't say, okay, you're over 65, therefore you cannot. But if they ask to work because they have symptoms or they have tested positive and they say, I want to come back in, we can say no. The EEOC says you can say no on that grounds. So it depends on the reason why they asked for the modification about whether or not you can prohibit them from coming on to the campus.
Yeah, for sure.
We just gave you that great lawyer answer. It depends.
It depends.
Helpful answer though. Thank you. Good.
So we were going to talk about actually in this section, these modified work schedules and sort of the distinctions being made on campuses between faculty and staff, the common requests we're seeing, remote work, partial remote work, job sharing, and then sort of a more flexible schedule depending on when people are able to do work based on their other obligations or, when school starts back up, what that ends up looking like. So those are the types of requests that we're seeing. And so I know most institutions right now are really building out from an academic perspective. Okay, what does, we're sort of getting through summer 2020, but what does fall 2020 look like? What programs will we be offering? Hybrid, online, virtual, in-person, et cetera. And then how are we, so with the students' needs in mind first to say, what is the core curriculum that we need to deliver? And then based on that, how can we modify things for those who are requesting it? So rather than having a series of modification requests drive what you're able to do, you got to start with the curriculum, you got to start with shared governance and the students, as we talked about in that first webinar, and design what it is you need. And then for a lot of these, they are being granted right now. So, we've seen that remote work can work for a while. And it remains to be seen how long that will work. Some of these courses do need to be in person. Some of the instruction is better in person. So if you're granting a temporary modification of a modified work schedule, I would limit it to just the fall term right now. I think we don't even know what's going to happen in the spring. So I'd just be careful about the motivation for how you get there, and then what you actually end up granting. But they're all, if you can administer these, you can certainly offer them. But again, if it's not ability, you're not required to.
Right, right. And I think the baseline.
Oh, go
yeah,
ahead.
the baseline of this, exactly what Natasha is saying, is you have to understand what your what your work environment is going to be. What's the curriculum? Because the baseline in any decision, whether you grant or deny, it's going to be based on business need. That's one of the things is, can you allow the remote work and still get the business done? Because that's going to be a neutral, sort of non-discriminatory basis for when you are granting or denying the individual requests throughout this process. Very similar to ADA, same kinds of concepts.
And I think that just the tricky distinction here is that a lot of institutions are really looking at what they want and need and should be able to offer, while also, you want to say, okay, for these courses, in-person instruction is better. For our type of residential traditional undergrad, in-person is better. And you have a slew of class action cases now saying virtual instruction was not sufficient. So you're balancing those competing messages. So when you say to your employees, we need you all back because virtual instruction isn't cutting it, you have to be careful about what you're saying about your class action tuition refunds. So it's like you're dancing on kind of a theme here.
So
very good point.
I've got another question from our audience that are very active today. As you know, the CDC recommends a 14-day quarantine after international travel. How do you handle when essential workers choose to travel internationally on their vacation and then cannot be allowed on site for 14 days? Do you have to pay for the quarantine time that the worker has triggered for him or herself? I can see you're both desiring, so we're going to go.
I'm just thinking about how that plays out.
Liz,
yeah,
you can go first, Natasha, and then I'll give an answer. Go ahead, Liz. You're up. Do you have to pay for it?
I think you need to look at state laws, because I think I'm going to let Natasha think about the California side of this, because it's your out of work activities, right? Thinking about so do you like that? I just sent you that toss that over the line to you. I think it's very reasonable to tell your employees that if they choose to travel out of the country, they cannot come back in the work. I'm thinking of federal law. I'm not seeing a basis that you need to compensate them for that time.
That's correct. Now, the key thing is, I agree with that, and we'll get to state law in just a moment, but you would tell them in advance. So if you opt to travel internationally, you will be required per CDC guidelines to stay away from work. And we're not going to have you working virtually. I mean, in theory, I don't know, but this presumes, I guess, they're incapable of working from home. So in that case, if they're not able to work from home and not able to return to work per the CDC guidelines, you could, I think, under federal law, not pay them for the 14 days. Now, maybe they could draw down PTO or other paid time in lieu. But Liz,
absolutely, right.
Natasha.
I had to comment on that because this goes to, and I think you could do a policy on this rather than saying internationally. I would broaden that out a little bit more, because, for example, I mean, if I think there are states right now that are saying if you travel to South Carolina, you come back, which is impacting my 4th of July plan. Side note, if you travel to South Carolina and you come back into our state, you have to quarantine for 2 weeks. So I think there is a very wise to have a policy that states if you go on travel and at the time of your travel, there are any active quarantine restrictions about travel to and from that location, internationally or domestic, include that in your policy, and that way you're not having to update it every other day when there's changes to it.
Okay, good answer, Natasha. State law input.
I agree. I think it's if you're traveling any sort of hotspot or potential exposure, including international travel, I think what you as an employer can make an argument that potential exposure is a direct threat to those other employees in your workplace. So in terms of having to allow them back, I don't think that that's required. In terms of paying them, I would try to have them work from home, but if that's not possible, then as David said, paying down the PTO, I think you probably need to look at the factors under the FFCRA to see if any of those
they probably qualify there.
Yeah, so they might draw down some if they're if it's a quarantine order. I mean, it's an interesting distinction between what's a quarantine order, which is usually from a local public health agency, and the CDC guidance,
Right.
which is advising people to self-quarantine after 14 days.
Okay, lawyers, I'm going to give you another question because they're coming in now.
Great.
This is fun.
Okay. One, this is like Jeopardy. One concern is that this is what I call the slippery slope problem.
Yep.
Once we start giving these modifications that you've done such a great job in outlining, there will be a rush and we will have minimal faculty left on campus. Any advice, Natasha?
Yes, so this is why it has to be, your curriculum has to come first. What's in the best interest of the students? What do you need to offer in person? What can you offer hybrid? Who teaches those courses? And it's tricky because there's been a lot of messaging about we want to keep everyone safe, we want to do everything we can for everyone. Like there was so many soothing communications to quell anxiety that, and frankly, there's a growing movement of faculty to say, you can't make me come back to work, or you're sacrificing the health and safety of the faculty at the expense of the administration. So, I mean, it's going to be a fight. So this is why you got to be able to point to, nursing clinicals, most likely got to be in person, art studio, maybe is that hybrid, like really saying this is what we need, and can we grant a temporary modification on that basis or not? So that's going to be a tricky one.
Yep.
And it also depends on the character of your institution, right? So like a lot of community colleges have gone completely online. A lot of traditional undergrad residents where really the value of the day-to-day campus interactions and the in-person teaching and mentoring is gonna play a factor into this. But hopefully you've got an overall design of this is what it looks like for fall 2020. This is our mission and goals, consistent with our stated institutional mission. And then hopefully the faculty are also, as we talked about in the first webinar, engaged in shared governance around what that goal looks like and that plan looks like, so that you have at least most buy-in. If this is why shared governance was so important in that first webinar. If you just top-down implement this, that's where you're gonna have a huge fight.
Great. One more, and I'm just mindful of the time because I know we're going to transition to some components here. But can you state that the faculty or that your staff must disclose when they travel to areas that require quarantine? So this is obviously personal travel. I'm reading a question here, but let's assume they go to personal travel to an area that requires quarantine, international or one of our adjoining states. Can you require disclosure? Liz and then Natasha. Yes, no. Liz.
If they're intending to return to work afterwards,
person,
I think yes.
Natasha.
Right, because that goes to the threat.
Natasha?
So I think what you might want to do here is, and this is interesting and developing rapidly into a much larger policy here, but I think like there's this tension between like, maybe I don't want to tell my employer I just went to this country, or maybe they'll make assumptions. So it's identification of here's what, if it's a hotspot, if they're a quarantine requirement after returning, you don't have to tell us where you went, but you have to tell us you went to one of those zones. I think might be a good way to sort of to split that.
Right. And rather than just saying international, saying hotspot travel, right? Because
which will vary, I mean, that's going to be fluid over the next few months.
If you go that route, yeah, the tweak has to be at the time they make the disclosure, because as demonstrated in the last 48 hours, hotspot gets updated quite a bit, and change it. Okay, let me just check quickly here, because some of these, we've got questions on monitoring travel. What? Oh, okay. One final. Then we're gonna switch. There are other questions, so I apologize in advance. We cannot get to all of them. What about a family member? The questioner poses a spouse, but someone. I'm gonna treat that question. Travel or activities about an immediate household member. I'm going to take moderator privilege. It talks about spouse, but it's broader than that. As a member of the household travels to a hotspot or becomes positive, do your policies embrace what our team members should be doing? Who wants that one first? Don't both volunteer at once. Natasha.
Natasha, I saw a hand go up.
We've had this. So this is super awkward, right? Super, super awkward. Who are you living with? Where are they going? I think maybe what we even want to think about is, okay, it's not just you have to self-report if you've had international travel. You have to self-report if you've had travel to a hotspot. It could be that if you have a reasonable belief that you may have been exposed, and that reasonable belief is based on travel to a hotspot, a family member or someone you live with being in a significant hotspot. Like I think there's going to be, and some of this can be folded into, we talked last time about the requirements to wear a mask, engage in social distancing, self-disclose if you believe you have a reasonable belief of exposure. But yeah, I mean, it's going to be, I start to get nervous about really digging into the details of who you're living with and where they're going. I think that's beyond what an employer can do.
Absolutely. If they report it's a family member, don't ask which family member, how they're related, just been exposed.
Okay. All right. Well, why don't we switch gears a little bit and move into some of the testing protocols and some of the issues and privacy issues, how we test, what we're testing, what testing means. And Natasha, why don't you kick that off? Valerie, we'll need to advance a slide or two here, please.
Speaking of things that make me nervous, COVID-19 testing, confidentiality, privacy. I mean, this is a brave new world for employers. This is not something we have ever seen, right? So what do we know? Baseline, employers don't normally conduct medical examinations. They can, but it must be job related and consistent with business necessity. You have to maintain the results of that medical exam in a separate confidential personnel file. So segregate that information out. And so we start to see things like a temperature check prior to entering a facility or building, if administered by an institution, is going to be considered a medical exam. So, you know, really looking at what kind of testing you're going to be doing. Some institutions are starting with questionnaires. Again, so you have to really think about what is it that you're asking? Do you have a reasonable belief that you have been exposed? Do you have symptoms? So really, really mindful of the privacy concerns here, what you're asking people about. Also, if I'm an employee, I want to know how long you're maintaining this information about all my private information that you're gathering here. So being mindful about how you start to think about gathering information. And then we do have some employers who are sort of engaging in the next level of COVID testing, but like at a minimum, we're seeing the questionnaires and the temperature checks. The EEOC is okay with the temperature checks. They think you should record the pass/fail, not the actual temperature. And then if someone does in fact demonstrate that they have that temperature, then making sure that there's a process for sending them home, notifying HR. Then we start to get into possible contact tracing if they had any interactions with folks in your workplace, or if this is the first day they've shown up and they have symptoms upon return to work. So sort of as a baseline, there's questionnaires and temperature checks, which limit what you're doing here, and then also be careful about making sure you have a consistent response to, okay, if you've shown symptoms, you got to stay home, you got to go home. Here's where the information's going to go. So
we're often seeing with the temperature checks, there's actually no records being kept. I mean, there's a pause point of somebody's, but it's somebody with the temperature, the temperature gun, and saying thumbs up or thumbs down if you get in the building. If it's a thumbs down, you're asked to step aside. HR or whoever the appropriate, the person taking the temperature contacts whoever has been designated, and it's discreetly handled. So then you don't even have records. The records aren't tied to anybody's name. So there's ways to do that you're not going to create any privacy concerns.
Yeah. So then we move into the next slide, sort of the next level of things employers are looking at. COVID-19, the actual viral test, which is separate and distinct from the antibody test. So the antibody test is easy. EEOC just said not permitted. No, employers can't do it. They base that on the CDC's interim guidance. So to the extent you were planning on doing antibody tests of your employees, that's out. Wouldn't recommend it for students either, based on how they're looking at this. So really what employers are looking at is the actual viral testing. And this is, the devil is in the details here too, right? Because this is only a snapshot in time. You can have a negative test and that may only be good for that day because somebody gets exposed that night. And so realistically, you have to look at what your institution can afford to do, whether it's going to do it internally, whether it's going to do it externally, whether your county is offering drive-up testing that you can also supplement your employee testing on. Phasing this, when are you going to do this? How often are you going to do this? Are you going to triage those who are in higher risk groups? And so this is being, I'm fearful that this is being seen as a panacea, and we may run out of testing supplies. Like it may be a complete nightmare here.
Yeah.
Liz,
But I think these tests are a great. Let's go back to the conversation we're having before. If somebody has traveled internationally and they want to come back to work, what do? Here's an option, right? So this could be one of the things. If somebody is going to be traveling, you have it in your policy or in your practices that prior to coming back from a vacation to a hotspot or anywhere, that you do this testing. And that way, that's one way to, that'll also give comfort to the rest of your workforce that you are doing these measures before people are coming back in, and that at least on the day they came back in, they did not test positive for on the viral test.
Yep. So I would really look at how frequently you can do this.
Right. I'm just going to add one sort of a practical point on this. This is expensive. You have a third party involved in doing the testing for you. You got to keep track of the data. In most workplaces, it is not required. It may be a best practice, but it's not required. And there are serious questions in my mind before you embark on this type of testing program. Most of you are not running, for example, it has been popularly reported, meat packing, meat processing operations, that type of thing, where the risk of transmission, because you cannot effect social distancing, you cannot affect other engineering controls to minimize the risk of spread. In those circumstances, testing is a much higher and much greater requirement. But in situations, in most of our workplaces, in the higher ed community, we don't have that type of risk level. And therefore, the necessity of testing is much lower. And it contains a lot of obligation and a lot of cost. So I just think that this is one that I think a lot of people initially were sort of, they had a knee-jerk reaction. Oh, we should definitely test. It feels like a good thing to do. We want to do that. Think about that carefully before you embark on this program.
100%.
Agree.
100%. Yep.
And
so
one follow-up piece on the so go ahead.
Okay.
I just had one follow-up piece on the antibody testing that's really, I think, is important to remember, and putting into context why EEOC is saying not to do it. You cannot, even if you test positive, if you have the antibodies, you can't be presumed to be immune. So there, can't rely on that okay, then they're ready to come back and to go into schools and churches. So the concept between why this shouldn't be done is we don't know what the positive test means, and it can't be relied upon. So that was the concept behind the antibody testing.
Yeah. Hopefully in 6 or 12 months, we'll have different answers. Testing may be more accurate, more readily available, more easily done. The disease may be subsided some, but at least for now, I think those are very good responses. Okay.
Yeah, so I think now we're going to turn to the next slide and really look at the other area that's keeping employment lawyers up at night and related to testing in terms of retention of information. And those are the privacy concerns. And so there are, I'll look at what we all just talked about, like who are you living with? Where's that person traveling? Where did you go on vacation? Like what's your medical record? Like the privacy considerations are enormous here.
Yep. And so here's a wearable beacon. I want it on you at all times, tracking everything. Go, you know.
Yeah, I know some people are looking at apps. Some people are looking at these wearable tracking devices. Really, really read the fine print on those contracts with anybody who's offering this type of service. What data is being gathered? How is it being maintained? Is it being maintained securely? What's the protection for the institution for data breach? I mean, if you think about the type of information that you're asking some random app to gather, you got to be really careful. And if you can design that app in-house, as some institutions have, that may be a much safer option. But yeah, this is a real area to think about and not miss. I mean, I know it's so scary to possibly have exposure in the workplace, but the privacy ramifications coming out of this are going to be significant for years. I mean, I was sort of like, well, should we just develop a new privacy practice at our firm? Because that's going to be like a whole new area.
Exactly. I also think, in addition, and we're going to spend most of the time on the privacy concerns here, but I think another consideration is some of the workplace morale issues. Are your employees going to be wanting to be required to wear a wearable beacon, knowing where they are, have their apps? I just think that it will have the privacy issues. We're going to get into more detail, but I just think there's concerns there about employee relationship issues and morale issues. I feel that is often a step too far in a way.
And I know in California we had some cases about tracking of delivery drivers where their truck, and they couldn't take a lunch break because they couldn't leave the truck, and so then the employer knew, oh, here's where they're taking lunch, or here's where they went, and so that was found to be problematic. So I think just some of the things that seem like they may be an easy tech-based fix, or you really got to weigh that out in terms of the information you're getting.
Correct.
Remember, the reason for the app is so that if there is a case of exposure, we know who may have been exposed to that person to do that.
Correct.
So an alternative, it does not impose the type of privacy considerations we've talked about before, is what we call gridding, that the people are, instead of having the run of the campus, that people would basically, under these circumstances, be designated to a more limited, confined, certain building, certain floor, assigned, please use this washroom, etc. It's a very different than you normally would think about, but it is an alternative. Why would we do that? Because then if we do have something that requires figuring out who may have been exposed, David got sick, so who was he in touch with last day or two? Well, we're going to know he was only authorized to go in these certain areas, so now I can look at the people that were within that grid and not have to worry whether he was wandering all over campus, et cetera. Now, obviously, some employees that doesn't, but yeah.
Yeah, those are some of the workplace modifications that we're seeing quite frequently. So, which, again, you would think, would I ever be comfortable telling my employees which bathroom they're allowed to use? 6 months ago, no, but now, absolutely. People on the west side of the building, on the 6th floor, can use this restroom, and you track that so that you know the exposures. That's definitely one of the workplace modifications we're seeing quite frequently, and limiting, saying you use the entrances and exits on this side of the building, and allowing the flow of people not to cross as often. Absolutely.
Can I ask? Good, Natasha, you've got a comment, and I've got an audience question I'm going to ask.
Go ahead.
Okay. The question is, we've talked a moment ago about testing, and now we're on privacy. Is the recommendation, if a person has a negative test result, can you require documentation, or do you accept a verbal response, and then what do you do with that information on testing?
Yeah, so the EEOC talked about this as basically a return to work certification, saying that you could ask that someone has been cleared to return to work. With the caveat, of course, that there are lots of false negative tests out there, and so you would treat it as you would. It should go through HR. It should go through the confidential process and through the file. But because the employee could pose a direct threat, you have the right to ask about this as a return to work qualification.
Okay, thank you.
Those
I was
results
gonna say
stay in
that-
their medical file.
Yeah, yep, separate. All this should be in the separate medical file. I was going to say that it's my impression that employers are in a really difficult place here in terms of the privacy concerns implicated by tracking devices, by apps, et cetera. But there's no sort of good non-tech option either, because then that option is really contact tracing by humans. And I think what we're seeing so far is, at least from the county public health agencies, some of them will do it for you. Some of them have said, you're on your own, good luck. But what we've seen is, even as they're trying to do it at the county public health level, it's extremely difficult and it's not working really well. So there's not a good solution right now for how to figure out where someone's been, how they've been exposed, if they may have been exposed, and who else they may have exposed.
Okay.
The other thing we wanted to cover was just what happens when you find out someone has been exposed, or when you find out that they have a positive diagnosis. So again, here, walking a fine line. You under the ADA usually have to protect someone's privacy rights, confidentiality. So to a supervisor, you may need to disclose something like that they will be out for this period of time, they're on a leave of absence, need to know basis, as you would with any other protected leave, whether it's a disability leave or just a plain sick leave or something caused by a COVID diagnosis, as we said, which may not trigger ADA. It's just that same information sharing is, this person's going to be out. I'm not going to say a lot more. And then this question becomes, it's obvious probably why they're out, because then functionally what happens is, if they've exposed people in the workplace or may have exposed people in the workplace, then the employer should notify those who may have been exposed that they should go get tested. And so this is, again, we're trying to figure out where somebody went, where the gridding becomes important so that you're limiting the scope. And so what you do here is disclose to the work group that, the 6th floor, West Hall, that they may have been exposed on this date. You're aware of someone who is present with a positive diagnosis. You don't need to disclose the identity of this, just that they may have been exposed. I think everyone's going to know and talk about this, frankly, and especially in higher ed, people tend to be sympathetic towards others and really are going to be concerned. But as the employer, it's key to be tracking what you're able to disclose, just like you would with any other type of protected leave of absence. And then you can follow up if that person who is suspected to have a exposure then actually tests negative, then you can sort of work backwards and retract some of that. You also have to make a disclosure to the public health agency, and it's constantly a weighing analysis. Like this, AEOC and CDC have said this is a direct threat. So if you've got if you're between a rock and a hard place on direct threat and privacy violation, for my money, I'd lean heavily on direct threat. So I don't know if you guys want to weigh in or.
No, I mean, I think the places where I see that this kind of becoming a slippery slope is if, you have an employee who comes, for example, we go back to the example of having a temperature today and being asked to step aside and not coming allowed to come in, don't call and say, David's not able to come into the office today. He had a temperature this morning. Boom, boom, boom. So, and that's so easy. That's going to be a slip. I can see, so just put those guardrails around, and I think there needs to be some guidance to supervisors and managers that they're going to need to be flexible for same day individuals not coming to work the same day. So getting a same day call from HR saying, you have an employee who's not going to be able to come to work today, and leave it there. Don't, so I think that's going to be a real time problem, and
let me just add,
be able to adjust to.
That guidance, this is part of the training as you're restarting and putting people back in the workplace. Your supervisors and managers should be receiving this training so that they understand how this is going to roll out, so everyone knows what to do when they learn this information, who learns it, what it means, and how to react and respond to it. And this belongs as a little module in that comprehensive training and guidance we've talked about as part of the rollout. Don't make it up on the fly when you're going through it. Okay, we're close, ladies. We have about a minute.
Yep.
So just a time
check. We previewed what's on the next slide.
The next slide we were talking about contact tracing, and I promise I'd learned to pronounce it before today, and I failed, Natasha. One of the things that we just want to be careful about again is that privacy concerns. If you're doing the contact tracing, if you choose to do it yourself, do not share who you can say the 6th floor bathroom, there was potentially exposure if you were in there between 1 and 2 on Tuesday. Be vague enough that they don't identify who it is, but specific enough to know whether they need to identify additional potential contacts. Again, we talked about when to initiate. Do it constantly with either beacons, or is it upon a report of a positive testing? Likelihood, I think most people are starting with a report of a positive employee. The constant collecting mechanism, while yes, it'll be the most thorough data and complete data, it just has a host of other privacy issues that may become unmanageable or untenable for the workforce.
Great.
That's sort of where we are. I think we can wrap. Any last questions, David?
No, we've cleared the questions. Any final thought? I'll go Natasha, then Liz, I'll give you the last word today. So Natasha, final thought.
Yeah, thanks for hosting this. Thanks everyone for joining. We know you are immersed in this stuff and super busy, so we hope that you found this helpful. And there's just know it's a brave new world for everybody.
Terrific. And Liz, you get the final word.
Again, yes. Thank you all. We appreciate it. Get your policies in order and keep things private. Thank you.
Terrific. Thank you both very much. Really, really, we appreciate it.
Thanks, everyone.
Bye-bye now.
We'd like to thank you for joining us. As a reminder, you may view the previous briefing on Fortney Scott's website at www.fortneyscott.com. Everyone who registered today will be registered for all future higher education focused briefings. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@fortneyscott.com.
Thanks, guys.
Thanks. Are we off?